Thank you to everyone for joining us today. This is certainly a very timely topic, and there are changes happening as we speak. There's a new executive order that's expected out tomorrow, so I think everything I say will be subject to change, but hopefully what we can do today is give you the lay of the land as it exists on February 28th, 2017. And I should mention that for anyone who attended the presentation yesterday at the National Restaurant Association, some of this content will be the same. I certainly will be available to answer any questions you have. So if you did attend yesterday and you didn't have a question, you had a question that wasn't answered, hopefully we can get it answered for you today. So. Oh, there we go. Okay. All right, so to start, let's talk about the executive orders. So a few weeks ago, the president released 3 executive orders on immigration. And all of these executive orders, you're probably aware of them. Each one of them could have a different but potentially substantial impact on the restaurant industry, and particularly with regard to undocumented workers, but frankly, all of these executive orders impact, all foreign nationals in the United States. So going in order, the first executive order, which was on January 25th, there were 2 orders released on Wednesday, January 25th. This one related to public safety in the interior of the country. And it basically, the primary thing that it did was to prioritize removal. So we understand that there have been some raids going on throughout the country in the past week at restaurants. We're not sure in terms of numbers, whether the numbers of raids have been any higher than in past administrations, but certainly there's been an uptick in ICE enforcement activity in the past week, and that is as a result of this January 25th excuse me, order. So the order prioritizes criminal removals, and we'll get to that a little bit more in a second. The definition of criminal is a little different from what, for example, the Obama administration was using. So that could impact the type of people who are being targeted during these ICE raids. And basically, the current administration is casting their net a little wider. So this January 25th Interior executive order, in addition to prioritizing criminal removals, it increases the hiring of ICE agents, so those are the people who will be performing the removals. It also withdraws federal funding for sanctuary cities, and there are numerous large cities by sanctuary cities, these are cities that do not cooperate with federal immigration authorities in turning over foreign nationals for deportation. And excuse me, if you've been reading the news, you've seen that there's a lot of controversy about these sanctuary cities, and as for now, the federal government is removing the funding for these cities. And then the last point I think is very important. This is both in the executive order that we're talking about now, as well as the other executive order on border enforcement that was also put out on the same day. And that is the empowerment of state and local law enforcement. So they have done this in the past. It has been problematic in some cases because immigration laws are complex, and state and local law enforcement are not always completely familiar with the immigration laws. So, there was an incident last week where a citizen of Puerto Rico was detained on a criminal offense, and then he was turned over to ICE. And as a citizen of Puerto Rico, he's a U.S.-born U.S. citizen, but it took several days, and even after he'd provided his birth certificate, they didn't believe him, and so it took several days to get him out of ICE detention. So that's just one example. There are other examples, but I think that we should be aware that state and local law enforcement, especially, in certain areas, they may be more vigorous than others, but there are some concerns about their ability to enforce the immigration laws depending on how well they may understand them. The second executive order that also came out on January 25th related to border security, and that is the order relating to construction of a border wall, which was one of our president's largest campaign promises. So that has been set in motion. This act also increases the hiring of CBP agents, so those are the customs agents at the border. And it also requires detention for immigration violators, and that's an important point because in the prior administration, many people were allowed, out on bond once they were arrested, and the current administration has stated that its priorities are not to bond out those people, so we can expect increased detention. There was a related announcement this week. The Obama administration had reduced reliance on private prisons. The Trump administration has done away with that, so we can expect that individuals who are detained for immigration violations, may be detained in private prisons, and we could see a growth of those types of detentions. So the third executive order is probably the one that you have read the most about. They've all been fairly well publicized and fairly controversial, but this one got the most press and has been the most challenged in the court. So this relates to the Muslim ban, which identifies individuals from 7 countries: Syria, Sudan, Somalia, Iraq, Iran, Libya, and Yemen. And it does 3 things with regard to those individuals. It says that they may not enter the United States. And as you may recall, when this order was put into place, there were people who were in mid-flight who were then detained at the border. It has been said that in the new order that they're drafting this week, that they've taken care they will not apply the order to people who are in mid-flight, so that's good. That was certainly one of the more problematic provisions of this executive order. The second thing that it does is suspend visa issuance. So if individuals are overseas and they were planning to come to the U.S., they will not be able to get a visa in their passport. And the third is that it suspends adjudication. So if you have individuals in the U.S. who are requesting asylum status, who are requesting, H-1B status, who are requesting employment authorization documents, those are all adjudications, and those are all suspended under this executive order. Now, these provisions of the order are actually not in effect at this moment. They were challenged in numerous courts, and the Ninth Circuit has put a stop to them for the time being. But the new executive order that has been promised to come out tomorrow is expected to reinstitute this ban. It will be in a revised format. I think that the initial ban was perhaps a bit hastily drafted, and so now that the administration has been advised by the court what the problems are, they're attempting to draft a new ban that will address those concerns. I do expect that the new ban will likely be challenged in court, but that's part of the process. So we can expect a new ban this week and potentially legal challenges to follow. The second provision of the executive order from January 27th that's relevant to many people, but particularly to restaurant employers who may employ refugees or asylees. The provisions suspend all refugee admissions for 120 days and suspend refugee admissions from Syria indefinitely. And that the total number of refugee admissions annually are reduced. And there's another controversial provision which also will likely be litigated, which is the prioritization of religious minorities in refugee admissions. So this third order, which came out on Friday, January 27th, was the most publicized of the orders. You may have read in the newspaper about sort of chaos in airports around the country, here in Washington, D.C., and in many airports, there are immigration attorneys who were sort of camped out at the airport that weekend. In fact, at our airport here in Washington, there are still immigration attorneys at the airport every day since this travel ban came out. So, the situation is changing. There are new interpretations that are coming out, and new nuances that are happening every day. So what does this all mean for employers of immigrants? And the restaurant industry is, of course, one of the nation's largest employers of immigrants. I believe that about 25% of restaurant employees are foreign-born. So probably you have noticed, if you employ immigrants, that there's a heightened concern among the foreign-born in the United States, both people who are undocumented and people who are here legally. We get calls, we've had many calls every day since these orders came out. The great majority of my firm's clients are here legally with work authorization. We get calls daily from those individuals concerned about how it may impact their travel, their ability to get a visa. There have been cases of mistaken identity, and so even if they're not amongst the targeted group, they're very concerned about traveling. We even have had calls from U.S. citizens who maybe were born in one of the 7 targeted countries, and they're very concerned about how this may impact them and their ability to travel. But certainly, the undocumented population are the most concerned of all. So regardless, I think, of your immigration status, if you have employees who are foreign-born, they are probably a little worried at this moment in time. The provisions regarding criminal aliens, as I mentioned earlier, relate not only to individuals convicted of crimes, but also individuals who were charged with crimes, whether or not those charges might later be dropped. If they've been charged, they could be a heightened enforcement priority. And even there's sort of a catch-all provision for individuals who are considered by law enforcement to pose a threat to public safety. So that's a fairly broad category. And there have been, as I mentioned earlier, targeted raids over the past few weeks, and we definitely have heard of this happening in the restaurant community. There's a link here that may be helpful to you, the ICE detainee locator. So if you do have an employee who has disappeared and you wonder if they might have been detained by ICE, you can use this link to see whether they're in ICE custody. You will need information such as their A number, their date of birth, their country of birth. So if you don't have that information, you may need to request it from a family member, or you could provide this link to family members. But this is a way to track down people who may have been detained by ICE. It's not cooperating to move to the next slide. Oh. Hold on. Okay, let me try this.
There you go.
There you go. Okay. Okay, so there are 3 ways that you might encounter the government at your restaurant, and those are through raids, I-9 audits, and site visits. So what we've been talking about so far are raids, and that is conducted normally by the National Fugitive Operations Program, which is part of ICE, Immigration and Customs Enforcement. And those are the most sort of dramatic type of raids. So, they're usually moderately civilized, although they can be very uncivilized with, armed agents storming the restaurant. So it depends on the situation. But in any case, out of all of these audits, these are the ones that are the most immediate and the most dramatic. And then the I-9 audits, those would be related to the I-9, which is the document that all employers are required to keep for all employees to check their employment authorization. And if you get audited for your I-9, you will, unlike the ICE raids where somebody will show up at your door and want to check documents immediately, in the case of an I-9 audit, you'll have 3 days to provide the document, so a little more leisurely. And then the last ones are site visits, and these these relate to the sponsorship of foreign workers. So if you have workers who you sponsored for an H-1B, for example, an L-1, the government could come to your restaurant to ask for documents related to that specific worker. For some reason, it doesn't want to let me advance the slides. Okay, bear with me just a moment. Okay, there we go. Relating to raids, the raid will involve a search warrant, so before you would be raided, ICE would have collected information from you. It could be through an employee of yours that was arrested. It could be through those no-match letters that you received from the Social Security Administration. There was a recent batch last year that came out in connection with ACA reporting. Could be as a result of an I-9 audit or as a result of an employee complaint. So there would have to be something that would trigger a raid, and that would trigger the initiation of a search warrant. And once ICE has gathered enough facts to have a suspicion that you have undocumented workers on your premises, they can come to the premise. They would seal the exits to the building so that all the individuals who are there can be detained and questioned by them. They would serve the search warrant on a representative of the company, and they will then go through your premises and your documents. And whatever is stated in the warrant, they're allowed to collect. So they can collect your physical records, they can collect your electronic records, they can question your employees. When they question your employees, if the employee admits not to being a U.S. citizen, then the burden is on that person to demonstrate their legal status. And so, one question is, do I have to answer their questions? Do my employees have to answer their questions? So you do have a right to remain silent in this context. If your employees remain silent, the likelihood is that they would ultimately be taken into custody. That still might be a preferable situation because that would give them the opportunity to obtain counsel and to prepare a strategy before responding to questions. Sometimes when people are questioned, on the spot, they might say something that they would later regret. So remaining silent is an option, although it does have its consequences. If they don't have their documents on their person, but HR is on the premises and can provide the documents, that will be fine. Otherwise, their family members are usually allowed to bring the documents to the company. The ICE agents will also likely ask to question the company's representatives. And they will arrest the employees who cannot provide legal status and detain them, and provide your company representatives an inventory of any property that they've seized. So what should you do if ICE shows up and conducts a raid at your restaurant? The first thing is, I would actually probably reverse these points, is call your attorney, and if your attorney is nearby, hopefully he or she can come to the premises. The raid will take a little bit of time, so normally that will give your attorney enough time to get there and to observe what's going on. Take a close look at the warrant, make sure that it's signed, that it's the correct time frame, and that they have correctly identified the physical area to be searched and the items that they're allowed to seize. Be sure to obtain the names of the ICE individuals who are involved in the case, and don't give any company statements to ICE agents at the time of the raid. It's also possible that the press may show up, and as attorneys, we would recommend that our clients do not speak to the press during the course of a raid. They do have the right to break into anything that's locked, so if you don't want your property destroyed, we recommend you unlock it for them. And this first point is a very important point. You do not recommend that your employees provide false or misleading information. Don't try to hide your employees, and don't try to shred documents. Those are some of the worst things that you could possibly do in this context. After the raid is over, these are a few steps that you can take to assess and limit your liability. So each individual company representative who is being investigated or charged should have their own counsel, and the company should also have its separate counsel. There may be conflicts of interest between different individuals, and so it would be important for each to have their own attorney. You might also wish to retain a private investigator to make your own assessment of the facts. This third point is frankly a good idea even before you're raided. That's to retain immigration counsel, to create a program of corporate immigration compliance. I hope that if you're restaurant operators that you have a program of immigration compliance in place, but if not, now would be a great time to do that. Conducting an annual audit of your I-9s. You don't have to audit them all, but select a random sample each year and make sure that your I-9s are in order. That's a best practice at any time, not only during a time of heightened immigration enforcement. And then lastly, if you do have individuals who are arrested and who will not be returning to workforce, make sure to hire a legal workforce to replace them. So the second type of government action that you might see, so we've talked about raids. That's what you're reading about in the news, that's what you're hearing about, and frankly, that's what everyone is concerned about at this moment. But these other two types of enforcement actions happen all the time and have been happening for years now, so some of you may have experienced them. And they're not quite as dramatic, but can be equally concerning for companies. So the background of the I-9 audit is the Immigration Reform and Control Act of 1986. This is the act that created the I-9 form. And the I-9 form, as you know, requires you to verify employment authorization, so it prohibits unlawful hiring. It also sanctions employers who engage in unlawful hiring. And then lastly, it prohibits discrimination. So although you have to verify employment authorization, you can't do it in a discriminatory manner. There's a new I-9 that just came out in November, so be sure that you're using that one. So what do you as the employer have to do? Most importantly, you need to examine original documents within 3 days of hire. You are not required to be a document expert, but you do have to make sure that the documents appear to be genuine, that the photo on the document matches your employee, that the documents are not obvious counterfeits. As long as you have done that, you've acted in good faith, and that's a legal defense if the documents are later proved to be false. You do want to avoid document abuse, so there's a specific list of documents that you can require. If you're only allowed to collect one document, you don't want to collect two documents because that would be over documentation, and that's actually could be discriminatory and could be a finable offense. So the documents you will see are required to show your identity and your work authorization. So you would provide either one document that shows identity and work authorization, such as a U.S. passport, or one document that shows identity, such as a driver's license, and another identity that shows work authorization, such as a birth certificate. And one thing that we see a lot are employers who collect Social Security cards in addition to, so for example, if somebody shows a driver's license and a birth certificate, you wouldn't also want to collect their Social Security card. That would be over documentation. And then these are the I-9 retention rules. This is very important. So you have to keep it for the later of 3 years from the date of hire or 1 year from the date of termination. And it would be a good idea in connection with your immigration compliance program to review your files every year and to purge those files that you no longer are required to keep. Because if you are audited, they will ask for all of your I-9 files, even the ones that you could have purged. If you didn't purge them, you have to turn them over. And so if there are errors in those forms, you could be fined for them. Whereas if you had purged them when you were allowed to do so, then your liability goes away. So you cannot purge after you are subject to an ICE audit, but if you purge on a regular basis prior to a potential audit, that will help to reduce your liability in the event of an audit. So if you are audited, you'll be served with a notice of inspection and given 3 business days, as I mentioned earlier, to produce your forms. And they also usually ask for some additional documents. The one that we see most often is just a copy of the current payroll, which lists all of your current employees. This is just a little flow chart that shows the process of what happens during an I-9 audit. And then I just wanted to mention E-Verify. This has been somewhat controversial. It's mandatory in some states, not mandatory in other. The current administration would like to make it mandatory throughout the nation. So I suspect that we will see more of this. As you know, it's an electronic system that allows you to definitively verify whether someone is authorized to work in the U.S. So these are some useful links for you. The M274 is like a Bible. If you don't have that, you should get it. It tells you how to fill out the I-9 form, and it answers many questions about the I-9. So that's available online. You can download it to your desktop. You can print it out, but very critical for whoever fills out your I-9 to have a copy of that. There are also some resources here about E-Verify and the Employer Information Hotline. That's an important one that relates to discrimination. So OSC is the Office of Special Counsel for Employment-Related Unfair Discrimination, or something like that. So if you have a concern about whether collecting certain documents would be considered discriminatory, you can contact them and they can help you. So the third type of visit that you could receive in the context of immigration enforcement would be a site visit. So right now, this is mainly happening for H-1B workers. H-1Bs are professional workers, degreed workers, and so this may or may not be pertinent to many of the restaurant operators. However, USCIS has said that they want to expand site visits to many other categories. Just to mention one, J1 summer work travel. So those are foreign college students who come to the U.S. to work during their summer break. I do believe that a lot of restaurant operators hire day and summer work travel participants, and there are other visa categories that are being targeted. So although this may not be so relevant to you right now, I do expect that it will become relevant in the coming months and years. So the part of the government that does these site audits is called Fraud Detection and National Security, and they're basically checking on employers who have filed a petition for or sponsored a particular employee. They're checking to make sure that the person is actually doing what the employer said they would do. So just as an example, if you have, I don't know, an H-2B worker, which is a temporary seasonal worker, let's say that you're a restaurant in a ski resort, you bring over 10 cooks from Brazil, and you said that you would pay them $15 per hour, and in fact you're only paying them $10 per hour, that's the type of discrepancy that FDNS is looking for. So they'll come on your site, they will have identified a specific worker or workers, they will have information about what you told USCIS they would be doing in terms of their job, their work location, and their salary, and they'll verify that information. So as long as you're doing what you said you would do, you're fine. But if there are discrepancies, now would be a good time if you do have any sponsored foreign workers to check what you filed with the Immigration Service and make sure that you're compliant with that. So these are some tips. If you are visited by Fraud Detection and National Security, it's important that your host, your receptionist, whoever is at the front of your restaurant greeting guests, is aware of what to do in the event of an FDNS site visit, but also in the event of an I-9 audit or an ICE raid. So it would be important to identify an HR representative or representatives at the company who should meet with such individuals if they show up at your workplace. And since probably one person cannot be there all the time, you should have alternative contacts so that your host or hostess is not the one, dealing with ICE or FDNS and providing potentially, confidential company information. So you want to make sure that this individual, whoever would be the first line of defense, whoever would greet visitors, is aware of what to do if any of these types of site visits happen. You can also contact your attorney. We are frequently contacted by clients when the government shows up at their site, and we can usually at least provide some guidance at that time. Make sure to get the identification details of the officer who visits you, and make sure that you grant their request to review documents. They do have a right to review their documents. That's one of the obligations that you have by sponsoring someone, is that you do agree to allow them to visit you to check up on the petition at a later date. So they do have the right to take photographs. They do have the right to interview your sponsored employee and your sponsored employee's manager. Don't make stuff up. Don't guess about any answers. You can always get back to them if you're not sure about something. Make sure to keep a record of everything that has happened. And again, this goes back to the first point. All of your foreign workers should be apprised to contact HR if they're contacted directly or approached directly by someone from the government. So finally, we have some guidelines for communicating with your employees in this time of heightened enforcement and heightened action with regard to immigration. There's a handy Know Your Rights card that's available from the Immigrant Legal Resource Center, and you have a screen print of the card here, as well as a link on where to download copies of those cards. And I believe that you can even have them mail you some physical cards, although they might be they might have a lot of requests at this moment. But these are cards that you could provide to your employees with regard to their rights if if the government shows up at your place of work. So I think the most important thing is the right to remain silent. You do not have to answer questions about where you were born and how you entered the U.S., and it could be potentially to your legal benefit to do so. This page relates more to ICE visits at a residence than it does to ICE visits at a business. So if ICE shows up at either a place of work or a residence with a warrant, you are required to open your door. So I think that requires some clarification. If they have a warrant, as discussed earlier, you should check the warrant to make sure that all the information is correct, that it's signed and dated. You can ask to speak to your attorney, and I highly recommend that you look at the National Immigration Law Center's website for other suggestions about what to do if ICE shows up at your door. If you have valid immigration documents, if your employees have valid immigration documents, they should carry those documents with them. They may not wish to carry a passport from another country with them because it could potentially be used against them. So that's their decision, but it's a pointer that they might want to heed. Do let ICE know if you have children and if you're concerned about what will happen to your children if you're arrested. So these are some additional tips about what your employees can do ahead of time if they are concerned about being detained. So they should know the number of someone that they can call if they're arrested. They should make a plan for the care of their children. We have actually, our office has been contacted in the past week by several clients who are interested in creating guardianship arrangements for their children. I think that's a very sad statement, but it is good to know that people are thinking about these issues anyway. You know, if parents are ultimately deported, it's important to think now about what would happen to the children. Be sure that they keep important documents in a safe place, and make sure that your contacts know how to use the ICE detainee locator and that they have the information that they would need to find you if you are detained. And then finally, this is some information about how individuals who are arrested or detained by ICE can find legal help. So there are some good pro bono resources out there. So the National Immigration Project has a great directory. The AILAlawyer.com would put you in touch with members of the American Immigration Lawyers Association. That's the National Association for Immigration Lawyers. And those would likely not be pro bono attorneys, so depending on resources, you know, that may or may not be the right place to look. And then Immigration Law Help is a resource that will show you how to find pro bono or low-cost immigration lawyers. These are some links for the Know Your Rights flyer that we just talked about. And hopefully El Restaurante can provide a copy of this presentation afterwards to attendees, since it does contain many useful links.
Yes, to that point, we will be posting this on our website. I'm not sure when it will be up, and there will be a copy of it there. And that website is www.elrestaurante.com. And I would like to ask if anybody has questions, if you could just type them in the question section. I thought there was one up there and it's kind of disappeared on my screen. So if there are any questions, if you could type them in now, we would be happy to try to answer them. And also, I'm going to give you my email address. I am the editor of El Restaurante. And if you, as you're going through this, come up with any additional questions, you can email them to me, and I will try to get an answer for you. My email is kfurore at restmex, restmex.com. Okay, and here is a question that we just got in. A gentleman is saying that he has 3 restaurants and keeps all employee documents at the corporate office. Is this okay, or should he have them at the restaurant, each individual restaurant, in case of a raid?
So legally, that's fine, as long as in the event of a raid, someone would be in a position to get those documents to the restaurant. So is the corporate office only open on weekdays, and are the restaurants open on the weekends? I would think that if the corporate office and the individual restaurants have different hours, that there could be a benefit to keeping those documents at the individual restaurants.
Oh, that's a good point. And I would think, I don't know if they come in at, like late in the evening, or like you said, after the corporate office would be closed. So those are things to consider.
Yes.
Another question, can they take people in if they are in the process of legalization? And she says, such as through a spouse.
Right. So that's a very fact-specific question. If somebody does not have legal immigration status at this moment, they will probably take them in, but it will depend, when you say that they're in the process of legalization through a spouse. So, just very quickly, that could mean a number of things. First of all, it could mean they've just gotten married to a U.S. citizen, but they haven't filed anything yet. So then they're not really, I guess, in the process of legalization. They could have filed something, but not yet had it approved. So then they would be, it would be in ICE's discretion. They might not detain that person, or they might detain that person but then release them. There's also something called a provisional waiver. So there are individuals who are here without authorization who are requesting that a waiver of an admissibility be granted based on marriage to a U.S. citizen, and they ultimately will plan to travel back to their home country to process an immigrant visa. So those individuals also don't really have a legal status and could potentially be detained. So I guess the answer is really it depends on where they are in the process of becoming authorized.
Okay. And another question, does the removal order include people with traffic tickets?
So by the removal order, I think we're talking about the executive order relating to interior enforcement and the memos implementing it. And the answer is probably not, but it does. There is that catch-all provision at the end which says that ICE can detain anyone that it considers to be a threat to public safety. So I think most reasonable people would agree that traffic tickets are unlikely to cause someone to be a threat to public safety. But I don't know, what if they had 3 tickets for reckless driving? So again, a fact-based determination, probably those individuals would be less likely to be a target. But if you get a very aggressive local law enforcement officer who wishes to interpret the administration's guidance very broadly, you could have a problem.
Okay. Another one, they're asking, this person says they have 1 restaurant. What employee documentation does she need to have on file now to ensure that they meet the legal requirements if raided?
Well, that's a very broad question. So it really would depend on, who the workforce consists of. So certainly, all employers are required to have I-9s for all employees. So I think the most important point I would make for all employers are to do, now would be a great time to do an internal audit of your I-9 files. So print out a copy of your payroll and make sure that you have an I-9 on file for every single employee. And go through those I-9s to make sure that they're properly completed. Have they been signed? Did you actually check, the correct documents for each person? Are they dated, et cetera? So this is a great time to do the I-9 review. So at minimum, you need an I-9 for each employee. If you have any employees who you've sponsored, you need to make sure that you have a copy of any documents that you signed for that person, so that FDNS shows up, if FDNS shows up at your workplace, that you could answer questions about, what promises you had made in the context of sponsorship. So I think, the I-9 documentation is intended to screen individuals who are not authorized to work in the U.S. So if you very carefully completed all of your I-9s and you don't have any undocumented workers or no apparently undocumented workers at your restaurant, then it's less likely that you would be the target of an ICE raid. So I would start with the I-9s. On the other hand, if you just got, you just became the HR manager at a restaurant and you haven't looked at the I-9s, and when you look at them, you see that you only have I-9s for half of your employees, and the ones that you have are not in good shape, that would be a red flag to get your compliance program in shape.
Okay, we have two more questions, and I think that should wrap it up. This question is, do U.S.-born children give illegal immigrants more rights to stay and work in the U.S.?
So the short answer is, so I think this person is asking, if you're undocumented and then you have a child in the U.S., does that give you rights? So first of all, when your child turns 21, your child can sponsor you. So we hear sometimes in the newspaper about quote-unquote anchor babies. Immigration lawyers don't like that term because, aside from the fact that it's a bit offensive, a baby cannot sponsor a parent, but a 21-year-old child could sponsor a parent. So I think that's the main way in which having a child could give some immigration benefit to an undocumented person, but 21 years is a long time to wait.
Okay. All right. And then finally, after doing the I-9 audit, you find errors like over documentation. At what point do you redo an I-9?
So I would encourage you, if you have questions about I-9, to consult with Immigration Counsel. There are very specific rules about what you should and shouldn't do to your I-9s. One very important point is don't ever white out anything. If you make any changes, you need to line it out and initial and date it. But I would encourage you, if you go through your I-9s and you see recurring problems, that's a good time to consult with Immigration Counsel.
Okay. Oh, and we've got a few more minutes here. What about employees that don't have documents?
I guess I don't understand the question.
I would assume that they're asking if you are employing someone and you know that they don't have any kind of documentation that they need.
Right. Well, and actually, before I answer that question, I can't get to this last slide, but there is an important point that I wanted to mention before we go, which is that there is the American Immigration Lawyers Association is having a National Day of Action. It's on April 6th. That is an opportunity to come to Washington and to meet with your congressional representatives and our firm will be hosting a group of restaurant owners and employees. So if anyone has an interest in participating in that event on April 6th, you can feel free to contact me directly.
Okay.
And I guess that leads into the question, which is that, if you know someone is undocumented, as a lawyer, I would tell you that you cannot continue employing that person. But, if you feel like this is an issue that, that you would like to address, I think that speaking to your congressional representatives about immigration and any challenges you might have in hiring and retaining employees, and if you do have undocumented employees, if you'd like for there to exist a way in the law for them to obtain legal status, because the problem, many people are undocumented because there is no way for them to obtain legal status. So if you think the law should change, my best advice is to come to Washington. Call your congressperson if you can't come in person, but if you do want to come in person, let me know, and I think we need to make our voices heard.
Okay, and then last question, are I-9s required for 1099 employees?
1099s are not employees, they're contractors, so the answer is no.
Oh, okay. Okay, well, thank you very much, Becky. I think this has been really enlightening. And again, this will be posted on our website. And you can also email me any questions you might have, and I will try to get an answer from Becky for you. That email address is kfurore@yahoo.com, and the website is elrestaurante.com. So thanks, everyone, and I hope that it has been a helpful webinar for you.
Thank you.
Thank you.